price, so we call people on it. It doesn't matter where.
So this is for HBD 2100.
Thank you.
Mr. Chair and members of the committee, I have previously expressed my belief in support of community policing efforts, and I've been clear about the fact that transparency and trust are key in building relationships between law enforcement and their communities, and I think that good cops and deputies are good for all parties involved. So this is with relation to hiring practices of the departments, and currently police chiefs and sheriffs are hiring new officers and deputies that when they have service with previous departments, very little information can be shared about the applicant's work with the previous department. So this bill addresses that by kind of untying the hands of the previous department's chief or sheriff to share information about the applicant with the applicant's signed waiver. And it allows for the men and women in uniform to discuss the pertinent information as opposed to HR kind of telling them what they can and can't share. There was an issue with the original language that was brought to our attention that was unintended, that once you open up a person's file, there may have been a case where they were working with other officers. And so this line amendment is to protect the other officers that were involved that did not sign such a waiver.
Mr. Chair, I move the amendment.
Second. Motion second to adopt the amendment. All in favor say aye.
Aye.
Opposed?
Thank you. And so this just provides, the information described in the legislation after the waiver has been signed. I've been working with the Newport News Police Chief and the Sheriff of Newport News, and we think it's a good solution for a more robust conversation between departments to make sure that each of the departments are able to hire the best of the best. There was an 18-0 vote in support with the Virginia Sheriff's Association's Legislative Committee, Newport News Sheriff gave Morgan support, and the Newport News Police Department support.
Questions from the subcommittee? What is to prevent law enforcement agencies from doing this currently?
So in my situation, there is the HR policy that comes from the city of Newport News that says that all they can say is the dates that they work for the department and if they were hireable or not, like rehirable or not. Like that's it. And so it doesn't even give them a fair chance to say like if there was an extenuating circumstance why they were not rehirable, to give any more information on that. And that is happening. I've talked to other jurisdictions that felt the same way, that it was like HR and the city attorney are telling the chiefs what they can and can't say, as opposed to the chiefs being able to talk more. And so it's happened between Newport News and neighboring jurisdictions, but also Newport News and jurisdictions further away.
Did this come to your attention from your sheriff or from
Police chief.
DCJ? Yeah, your police chief. Oh, okay.
Yeah. And then the sheriff was on board with it. I understand that the sheriff has a little bit more leeway than the police departments,
Oh, okay.
but they are supportive.
Did you bring anyone to speak on the bill? Is there anyone here wishing
They
to speak?
couldn't make it up actually because Newport News has 40 positions that they're trying to fill.
Okay.
But they are supportive, and I talked with the Sheriff's Association and the sheriff again to reconfirm last night that they are supportive in there.
Okay. Yes, sir.
Yes, my name is Mark Young. I live in Prince William County, Virginia, and I'm in support of this bill. It's
Okay.
good to know who public employees are.
Do you have a history of law enforcement experience, or are you just a concerned citizen?
I'm just a citizen, long-term
Wonderful.
citizen.
Well, appreciate you coming down and getting up early. Yes, sir.
Chairman, Kenny Hancock, Department of Criminal Services, we support this bill for demonstration.
All right, I'm just running through the section of the code.
Yeah, Mr. Chairman, just
Delegate head.
a couple of questions. On line 27, as we're looking at this, if you're talking about disclosing any information related to an arrest or prosecution of a former appointee or employee, if we stop there, I would assume that anybody is going to run a background check before they hire a law enforcement officer. And I know that even in the case of the ones that I run for my employees at home care, if there's been an arrest or a charge, that shows up on the state police background check. And so we know about that, there's no way you can not know about that. But I get real concerned when you go to including any expunged arrest or criminal charge that would otherwise be prohibited from disclosure. I mean, that sort of, that gives me great pause. If it's been expunged, getting something expunged is not an easy thing to do, and there's always a cause for that.
Okay. Delegate Price.
Mr. Chair, if I could say, so there has been some conversation as to the difference between a background check and a background investigation. And so just wanting to make clear that, yes, background checks can definitely catch things, but if it's not clearly defined what is involved in a background investigation, then we definitely want to make sure that it's caught. And I'm actually amenable to striking the language about the expunged information if that gives you heartache.
All right.
Mr. Chair,
Delegate Rasul.
I would move to amend the language on line 28 after employee all the way through line 29, semicolon before subsection
Two little I. All right, you just want to start after employee?
After employee, so including,
So it'd just be one little line, any information related to an arrest or prosecution of a former appointee or employee.
I would, yeah, we would keep that language and then the second half of one line.
All right.
Mr.
Delegate
Chairman,
Head.
I would propose an alternate, and that would be striking the word including and inserting the word excluding on line 28.
All right, I'm going to go ahead and second Delegate Rasul's amendment so that is before us. Delegate Head has proposed a substitute amendment. Once he gets a second, he can explain it. So. All right, thank you, Delegate Will. All right, Delegate Head, what is your thinking?
Well, my thinking there is that if you just say, any information related to, would still include the expunged, presumably could be argued that that could still include that. But if it's been expunged, I want it, if we're gonna start opening that up in code like this, and something has been expunged, I just assume we leave it expunged.
Mr. Chair, I withdraw my amendment
Okay.
in lieu of Delegate Head's amendment.
All right. I'm just interested a little bit more from council about 19.2, 392.4. These are disclosure prohibitions, I guess.
Yes, Mr. Chairman, would you like me to read the relevant part?
Yes, please.
Subsection B of 19.2, 392.4 reads, agencies, officials, and employees of the state and local governments shall not, in any application, interview, or otherwise, require an applicant for a license, permit, registration, or governmental service to disclose information concerning any arrest or criminal charge against them that has been expunged. An applicant need not, in answer to any question concerning any arrest or criminal charge that is not resulted in a conviction, include a reference to or information concerning charges that have been expunged. Such application may not be denied solely because the applicant's refusal to disclose information concerning any arrest or criminal charge against them that has been expunged. Subsection A says something similar, but it's an employer educational institution. So for the purposes of law enforcement, we'd be looking at B.
Okay.
Mr. Chairman, I would say that that this section being more specific would control. So there's nothing wrong with saying exclude, notwithstanding the provisions of 19.2, 392.4, but even if we don't make reference to it, that would be the controlling.
Okay. Do we, if we include that language that just says excluding any expunged arrest or criminal charge in accordance with 19.2, 392.4, are we creating an issue with the rest of what's in
Chairman, understanding if that section is gonna prevail, even if it's not listed there, then I'm actually fine with delegate renewal as an initial.
Boy, this is a lot of kumbaya today.
Just wanna make sure we get that right, you know, if we're.
Do we need to reference back to that section, just,
Can we just strike
as
it?
belt and suspender, so it says, one little line, any information related to an arrest or prosecution of a former appointee or employee.
Make that a period.
I guess it's understood that it's in accordance with 192392.4, we don't have to reference that section.
Mr. Chair, for the legal analysis side, we wouldn't need to reference that section. I could see a situation where a police chief is curious about whether he can disclose something that's been expunged. So I think legally we're on good grounds to strike it completely, but if that would cause confusion, there's also no drafting problem with leaving a cross-reference.
I'm thinking, I think it's gonna confuse the situation if there's already a section of the code dealing with what information related to arrests, and what information's allowable. To try and reference back to it, I think, just taking out one little I is probably your best bet, because then you're not trying to change that section of the code, you're not trying to change what information is provided to potential employers. You're just referencing it here in this section. So, isn't that correct? I mean, this bill is not changing the information that's being provided.
Are you talking about one little
Yes.
I entirely?
Yes.
I don't know of anything that would prevent a law enforcement agency from conducting a criminal background check that would give them the information about the arrest or prosecution, but if there are HR policies in place that say that they can't give them anything, I don't know that agencies would currently be providing that.
Okay, all right. So the balance may be to leave in one little I and stop it with employee. Although you could say excluding any information that would otherwise be prohibited from disclosure in accordance with 192392.4. Is that? All right.
Mr. Chairman, if it would be good for me to amend my motion
Yeah.
to that, I would so.
I like where you're going, I just think we need to make it broader and say
Let's
any,
be clear.
excluding any information that would otherwise be prohibited from disclosure in accordance with 192392.4. All right.
Second.
All right, all in favor say aye.
Aye.
Opposed? All right, that's,
Mr. Chairman?
all right, Chris?
Two little I there. I also have some concerns about just information that might be there on a civil suit, and this is a question of ignorance. Are civil suits not available as information on civil suits primarily? Is that information that could be obtained in a courthouse search, courthouse record search
Yes.
of someone? So if you were looking for that information could be found on the part of the employing person without going back to an agency involved in this. My concern is that civil suits, if they are founded and the person was, if a civil suit was filed against a prospective employee and the verdict in the civil suit was for the plaintiff, that's gonna be recorded. And if public information, that's fine. But if the suit went in favor of the defendant, or it's still an open suit, and even if there's information that's out there, that gets into some questionable HR practices, I think, because these guys are out there in a situation where people get upset because they got pulled over, right? And we don't wanna we don't wanna limit a bad actor. And Doug Price, I want you to understand, I understand exactly where you're going with this, and I agree with you, because I really am, but I just don't wanna have somebody that is just doing their job, and somebody got upset with them, sued them, and this is still pending, that might cloud the water for them to be able to move on to another place of employment. So, is there anything we can do to clean up that one, or? or since it is readily available to an employer that's doing due diligence, might we just take that section out completely and then leave three little I, because I do think that three little I there is fine. I mean, and that really, I think, gets more at the heart of what you're really after, and I think that I'm good with it.
If
All right, like, maybe I can address Delegate Helms just by, as a question, just by looking at the language here. It says civil suit regarding a former appointee's or employee's employment or performance of his duties. So this, if the civil suit is related, I guess what you mean is if someone pulls you over.
Well, Mr. Chairman, I think any civil suit that would be filed is because you know, if it's a cop doing something and somebody got pissed off and going to sue you for doing that, anything that they did would be in relation to their performing of their duties, and that's the thing that's where that gets really muddy, cloudy for me. So
I'm less concerned about two little I's than about three little I's, because I think three little I's is a little bit more wide ranging and less, and needs to be drawn a little bit more tightly. But
Maybe you could put some language in there that says judgments against, civil suits or judgments against, related to his duties. I mean, so you'd have the discretion, so you'd only look at the judgments that are against
once,
the employer, not anything pending.
the first thing I think, I mean, I have less of a problem with it because what you're dealing with here is a situation where a former officer is applying in another division for a job and has signed a waiver, and down here towards the bottom, that he's okay with the guy he's applying to calling his old employer and saying, can you share information about this applicant related to charges, prosecution, civil suits, and at that point, and investigations, internal investigations. I bet the former employer is going to have information about civil suits because they're going to be paying for his defense if it's in the line of work. So,
Mr. Chairman,
Elliot will.
are there federal guidelines that come, you know, just overall hiring guidelines and so forth that we're running this?
I'm not aware of any.
Mr. Chairman, I'm not aware of anything.
Okay. Elliot had.
I'm not sure. I'm honestly, the more I sit here and look at this, Mr. Chairman, I'm very, I think, again, as I said, I appreciate where this is trying to go, but I think that this maybe is not quite ready for prime time yet, and so if I may move that we lay this on the table with the expectation we will hear it again, and maybe we can work on this again, try to get the language right.
All right. There's a motion to table. Is there a second?
Second.
There's a motion and second to table. It's non-debatable.
Mr. Chairman, I have a point of order.
All right, point of order.
Is there anything that the committee could direct this to go to, if this is the will of the subcommittee, to study this in off-season?
Yeah, I'm gonna, this is the second bill that Elliot brought that raises some interesting questions that I haven't considered before. And so I do appreciate where she's coming from. I said there's no debate, but I'm just gonna say, I appreciate where she's coming from because I agree that sharing of information helps get a better police force and better sheriff's department. So I'm willing personally to work with her over the year to make this right, get this language in a proper order. I think I do want to hear from the sheriffs and from the police chiefs and find out if this is more of a pervasive problem. Because again, this goes back to your problem in your other bill. Came out of your jurisdiction, good idea, but is it a problem statewide? I mean, is it necessitating a statewide solution? So I will be working, happy to work with you on that. And if we can pull in the Sheriff's Association, maybe we can have Sickles.
Morning. Morning. We could have a substitute.
All right, House Bill 2224. What's your motion on substitute? Second, I've seen that's okay.
The,
Rick Sullivan, was addressing, or was curveball on a substitute.
be too tricky around here.
No, you can't. Actually, it comes back on there.
Right.
All right, so Delegate Sickles to explain the substitute.
Okay, the purpose of this bill is to take a step toward more professionalism, more expertise on the parole board. You know, the parole board still has somewhere around 4,000, maybe more, people eligible for parole from the pre-95 legislation. And right now, the board serves at the pleasure of the governor. There's no terms on it, they just serve at the pleasure of the governor. And this bill simply would create a committee to help formalize people that are qualified to be on the parole board, to give him or her a chance to pick from a list. Now, the problem with my bill is, the way it's drafted right now, is that the governor really hates it.
Did you get some feedback from the governor?
Yeah, they've come and talked, they don't like it, and I'm not sure they would like it if we made the change I'm about to suggest, but there is merit to this bill, even after what I'm about to say, and that is that on line 15, the new language there that says the governor shall select each appointee from the list of eligible parole, that would be a list of 5, by the way. Shall select from that list. And, I would offer that if we substituted may there, they still wouldn't like the bill. But I would be willing to go forward with it because there's merit to this bill even with a may. There's no process now. I think this would be helpful to them, not hurtful, because now, it is chaotic. I know if you've ever had any dealings with administration on trying to find appointments for people from your area, this and that, it's a chaotic system. This is to put a little structure on it, so there's a committee standing out there that can help put 5 people forward that the governor could select from. If he didn't want one of those 5, maybe that would lead you to raise a question. What was wrong with this person? What was wrong with that person? And that may be why the governor wouldn't like the legislation, even if we change it to may. So there's an enactment clause at the end that, since we're going to a 5-year term, did I mention that? That's another big change here. We're going to serve at the pleasure, we're going to a 5-year term.
That's a big change.
That you're staggering.
You're staggering, yeah. In the real world, the new governor comes in every 4 years. I'm not sure they would fire all 5 parole board members now. A couple of them are part-time anyway.
Right.
And but this would, this is the enactment language that would stagger that, getting it into the 5-year terms. And then, as I've talked to the chairman here about before, you can see who would be the members of the parole qualifications committee. One appointed by the House Speaker, one by the Senate Rules, one non-citizen member from the Commonwealth Attorneys, the Prison Advocacy Group, which is already the case in Secretary of Homeland Security, not Homeland Security.
All right. Right now, full board is all 5 members, the pleasure of the governor. We have no say, we have no input, and my suggestions were unconstitutional at the last meeting of us getting a share of those picks. Or did I make that out loud, or was it just in conversation with you? That I originally suggested giving us some of the picks. As an executive agency, we can't do that. But we can do this, and the way he structured the appointments, actually his, Senate 1, House 1, and Commonwealth Attorneys 1, and then Prisoner Advocate 1, Governor 1. It is an excellent balance in my view. I share the gentleman's view that I can't imagine the governor's office supporting this. But it's in a form that I can support. Now, if you want to say nay, select, then you lose. But, anybody here in the audience wish to speak for or against the bill? Yeah, exactly.
Well, I think there's,
You can do it now.
yeah, this is just to be helpful. I mean, I've tried to help various governors find people for certain jobs. I know that when we select judges up in our area, we rarely put somebody on the bench who hasn't been several times. We get to know them, to interview before us. I think that having a list of people out there that a group of 5 different people think is qualified is helpful. That's the benefit of the bill. I think there is some benefit to having 5-year terms. But if we can take a vote on this, but I just strike the bill if it has to be shall.
And that's, I think where I will take it as far as you will let me.
Yeah.
But if you're gonna strike it, if we keep shall in there, I can't, then I think
Well,
we're at an impasse.
it's not me personally.
I understand.
I just, Bill, I don't
Chairman,
want
We'll entertain a motion to table and commend the gentleman for his efforts.
Just to let the delegate know that unlike on my bill on franchising, I would be happy to help the gentleman override the veto that would be coming. So it was just so we're clear on that.
Yeah.
That's
Yeah,
right.
right.
That's what you do. That's what you do.
Well, yeah. I think I have more problems than just that if I do.
Well, I'm just saying, come on.
All right, well, you put a lot of time into it, so I appreciate it. Can I get a motion on it?
I want to strike the bill.
You wanna strike it? All right.
It's okay.
How-
Well, I
how
don't
do we
care. You can lay it on the
procedurally-
table.
Whatever, you okay? All right, all in favor of laying the bill on the table, say aye.
Aye.
Opposed?
Now, once you think
All
about
right,
all
the
the
last bill is Delegate Lingenfelter's bill, which he said he wanted to go by, but this is our last meeting, so I can get a motion to report to the full committee without recommendation.
So moved.
Second. All right, all in favor say aye.
Aye.
Opposed? All right, he can deal with that one himself.
Yes.
Thank you.
So we're done?
Thank you all.
8:30.
Half an hour. What's that?
8:30 in House Room 1 tomorrow. We're in the Capitol.
Great. Great.
We're gonna
Sorry, we
sign
walk
on
out
that.
on that first one, but it was actually worth, talking about kind of chronology and I got kind of bogged down in the weeds.
Was that on the first one?
Yeah, so thank you.
Yeah.
I'm setting me on the right
And that's,
course.
yeah.
I'll work with it.
It's a great idea, but yeah, it's clearly not ready for.
Both of their bills. Sometimes when they come out of your own district. All right, thank you guys.
What's the deal with this moving back and forth between the Capitol and for me?
I don't like it. It's, anytime we're over in the Capitol, it's very difficult.
Does anybody know why? Just out of space, too much?
No. The reason the chairman said he was doing it is the NRA is apparently sponsoring a breakfast tomorrow, and that's in the Capitol.
Yes.
And
So it's right next to the NRA breakfast.
And, well, Chairman Lingenfelter originally wanted to do it in the same room with the breakfast, and we told him that probably created a perception issue, and we needed to do it in a separate room, but we could do it over in the same building, and then you're right there for caucus anyway.
How are you? There's been a number of, various, but yeah, it's no big deal.
Yeah, but no, that's fine.
Just kind of can be handy, but
Yeah.
whatever.
No, it was a way, y'all were over there for the NRA
Yeah,
breakfast, and you had to come back over there for caucus to just keep you there.
good enough.
Forgetting that some of you have other places to be.
And if you guys don't like going back and forth now, just wait till next year.
Because this is practice.
Yeah.
Practice.
That was pretty smooth.
Two tables
Hey?
It should take you long to prepare Clive's subcommittee report.
No.